Hi, I'm David Chapman from the University of Central Oklahoma, and today I am in Montreal, Canada at a conference for the Association of Real Estate Licensing Law officials. So that's what we're doing here in Montreal, and maybe in my background you can actually see, if I turn around, I can see a nice garden on the rooftop of a building behind me, which is really cool. Today I want to talk about the ownership of real property. This topic has lots of terms to get our arms around, so a lot of it I'm going to be kind of just telling you what things mean and their significance to the ownership of real property when it comes to investing in real estate. A little bit of history I think is in order. Going back whenever the United States was founded, we were founded by pretty much the British and the French, and so we acquired a lot of their laws. And when they first came over, we had something called feudal ownership, and under that the king owned everything, and then he dealt out land to his servants for a couple things. The first thing that he required of them when he gave them land to utilize was he required security and loyalty, two things. And so in return for the security and the loyalty, and basically keeping him king, he let them use the land. At some point in the process of feudal ownership, he actually gave the servants or the lords the ability to rent that land out. And when he did, they were then called landlords. So that's where you get the term landlord. So when you're in the pub tonight, ask somebody if they know where the term landlord came from, and they'll think you're really bright. So that's the term landlord, and that's where it came from, was the feudal type of ownership. Well, as time went on, that wasn't enough, and so we switched to a new method of ownership called allodial. And under the allodial system, people now had the right, those lords had the right to sell their land, and they had rights associated with their land. There was some rights that the government kept when they gave the rights to the citizens. The ones that they kept were police power, escheat, eminent domain, and taxation. So they kept 4 rights with the government when they transitioned or conveyed to individual ownership in the United States. So they kept police power, which gives them the power to enforce safety and security. Secondly, taxation, to pay for the infrastructure and the roads that they were putting in. Third, escheat. Escheat is when you have somebody pass away and they do not have any heirs, or they do not have a will. That escheat determines that the land would go to the government. And then the last one, eminent domain, is where they take property for just compensation and for public use, to build roads and utilities and such. Okay, so we transitioned into personal ownership of land, and when we did that, the major rights to the land that were held by the owner are, number one, possession, which is the actual holding or occupying the land. Secondly is use, the employment of the property, the use of the property. The third one is enjoyment, the right to use without interference or harassment from others. And the last one is to dispose of it, the right to sell, lease, mortgage, give away, or otherwise dispose of the land. So those are the 4 things that, or the 4 rights and that were given to individuals. So how these rights are held and differentiates the various land interests, or what we call estates, that can be owned. So in modern law today, The right to dispose of a piece of property, which includes the right to sell or mortgage it, is the best test of ownership that we have. This is the crucial right that is given, more than just possessing something, which you can do without ownership. You can get rid of it. You can actually sell it, give it away. So that's the best test of ownership that we look at going forward, the most critical right. So what is an estate? You hear people talk about estates. The estate is a definition of an interest in the land. So it is the sum of the property rights and other things affixed to the land. So what we would call improvements, if you remember back from earlier sessions. They're given a duration of time, including infinity to forever. The estate is concerned with the land, and the ownership is concerned with people. Estate is concerned with the land, and ownership is concerned with the people. So there's a differentiation there. The two, they're not separable, but there's a differentiation there. All right, so we talked about the difference in feudal and allodial ownership models and when that in history and when that took place. Major classes of estates. We have the very best ownership that you can have is what we call fee simple absolute. Fee simple absolute. The best ownership we can have. Well, if that's the best ownership, then there must be some other ownership models, and there is. Under fee simple absolute, it is the highest and most extensive estate in common law. It is inheritable and not limited to a particular class of heir. Termination of the estate can be accomplished only if the owner dies without a will and without heirs. If these two circumstances occur, the property passes to the state by a sheet, which I talked about earlier. A sheet is one of the rights that the government kept, and that's why. Okay, so that is the best, fee simple. So like I said, there must be some other ones. Well, the next one's called fee simple conditional. If the owner places a limit on which heirs are entitled to inherit the property, a conditional estate may be created. Okay, so there's just some conditions put on the ownership makes it fee simple conditional. The next one we talk about is fee simple estates of potentially limited duration. So the fee simple conditional is who can receive the transfer of the property. The next one is the duration. And under duration, we have these words of conveyance that determine things from the grantor to the grantee. So the words of conveyance to the grantee can read, for example, so long as the premises are used for a public park, or until premises are no longer used for a public park. So things like that that determine ownership based on something happening. Another one of these types of fee simple estates of potentially limited duration is one that we call fee simple to conditional subsequent. This one, the words of conveyance to the grantee contain a method of disposing of the property in a clause in the event that limiting conditions are not met. So if you donate a piece of land to a church and you give them 5 years to do a fundraising effort in order to build a church there, and they don't raise the money and they don't build a church in the 5 years, then maybe that property can resort back to the grantor. Okay, so that would be an example of fee simple subject to condition subsequent. The last one of the three there that I'll talk about is fee simple subject to executory limitation. This form of estate is similar to fee simple subject to condition subsequent, in that the distinguishing feature to this one is that executory limitation causes a transfer of the interest to a third party named in the instrument. Okay, so rather than going back to the grantor, it goes to a third party. So in that case, I would say if you don't build on the land for a church within 5 years, then it goes to a third party. It goes to another church, or it goes to another individual to do something else with the land. So the point of all three of these is that there is some sort of potentially limited duration of ownership and determining of ownership. And so these clearly have other methods of determining things than does the fee simple absolute. Okay, but in general, those are the different types of estates that we see. Okay. Conventional life estates is another one that's worth looking at. Life estates for grantees' life. So life estates are a method to go in and purchase a property from somebody and allow them to continue to operate or use the property for a purpose until their death. And then at their death, it will come to the remainder man. Okay, so it'll go to another party. So that would be a life estate. There are some legal life estates too that are worth talking about. The form of estate is created by statute, not common law, this legal life estate. The trust of those states to protect the interests of parties in a marriage. So we have these terms called dower, courtesy, and homestead protection. These three things that we talk about when we talk about legal life estates. A dower, to be eligible for dower rights, a wife must meet three legal requirements: a valid marriage, possession of the property by the husband during marriage, the death of the husband. Then you can have the dower claim. In that, a wife's dower rights, a purchaser of property must obtain the wife's written consent to the sale, either through signing the deed with her husband or through a separate quitclaim deed. Okay? The second one is courtesy. Very similar to dower. Courtesy is the rights that state a husband holds benefits to his deceased wife's property. Okay? So courtesy has to do with the husband's rights. Dower has to do with the wife's rights in a marriage. The third one is homestead protection. It's associated with marriage and provides them almost equal protection for the husband and wife. All right. So you have the dower, courtesy, and homestead protection as a parts of the legal life estates, which is a type of present possession freehold estate. Okay. Future interests. So when we talk about these life estates or any type of estate, who gets the property in the future? If we have this thing called reversion, if a grantor conveys an interest to a property to someone for that person's life, a life estate like we talked about, and makes no disposition of the property upon the death of the grantee, the law presumes that the grantor intends that the interest would come back to himself. So reversion means it goes back to that person that conveyed it, the grantor. So we have this other one called remainder. Remainder is like reversion, except that it favors a third party. So that person, we sometimes call them remainder man. So when somebody with a life estate dies, typically it goes to the grantor. But in this case, it goes to a third party, and we call that remainder. Okay? So we have reversion and remainder. All right, so now we get into leases, non-freehold estates. A freehold estate means that there is ownership. A leasehold or a non-freehold estate means that there's a lease on the property. And we have different types of leases. We talk about 4 types of leases. The first one we talk about is tenancy for years. This estate is defined as any leasehold with a term that must end on or before a specific date. So it has a date associated with it. Tenancy at years. Okay? Most states limit the number of years by which a leasehold may be created. And sometimes that's 99 years that you'll see in some states. Second one is tenancy from period to period. Sometimes we call these month-to-month leases. A period, the duration of this lease is expressed as from time period to time period. So month to month, year to year, that's what we call a period to period. The permissible periods may be from a day to a year in length. A term longer than 1 year would fall under the 4 years classification. The periodic tenancy is a leasehold found in a month-to-month apartment lease, so we see those all the time. The third one is tenancy at will. This type of leasehold estate lasts as long as both landlord and tenant wish it to last. Either party may terminate this lease at any time. Usually, however, there's a terminating party must satisfy a notification requirement. Most states require a 30-day notice. So that's tenancy at will. And then the last one is called tenancy at sufferance. This one, the tenancy is without a right and without the landlord's consent. So think about somebody who started out with a legal lease, and the lease is up and they stay in the property. They would be staying as tenancy at sufferance. And so the only difference in tenancy at sufferance and a trespasser is that tenancy at sufferance started there legally with a lease to start with. Okay, so those are the 4 types of leasehold estates. All right, so now we get into other interests that are not deemed estates or don't actually have ownership, but they have rights. The first one we want to define is easements. An easement is a right to use a piece of land, but carries no other rights of ownership. So under law, the right of use is not the same as the right of possession. So an easement would be like a utility company has the rights to come in and use that land so they can dig it up and put pipes under it. Oil companies have easements on land. They have blanket easements on large pieces of land. They have specific easements on other types. The second one is a license. A license is similar to an easement in that it grants the right to use a portion of land, but it differs from an easement in that it is revocable. For example, a license of a guest to use an owner's home may be revoked at any time by the owner. So licenses are like parking. Whenever you go to park a car in a parking lot, that would be an example of a license. It's not an easement. It can be revoked. The third one's just a word it's called profit. We don't see this a lot. The right to serve and remove certain things attached to the land, such as ore, timber, is called in the law a profit. Okay, so you might see that term at times in real estate called profit. And then the last one that we talk about here is covenances. Steps an owner takes to restrict the land use, the use of land under his control are called covenants. So you hear this in like a homeowners association type situation. You have covenants. A covenant can benefit the non-covenanting party, but does not entitle him or her to personal use. Okay, so that's covenants. So those are some land interests that are not deemed estates or actual ownership. All right. So now we get into the classification of property ownership. And whenever you buy real estate, you have to make a decision on how you're going to own the property. And so we have to make and understand the different options that there are in ownership. The first one is sole ownership. So this is property that's held by one person, And we call this estate in severalty. So don't let that confuse you. The severalty confuse you. That doesn't mean several. This is ownership by one person. Okay, so don't let that confuse you. So that's sole ownership. The benefits of sole ownership is that you make all the decisions. The problem with that is you take all the liability and you don't have any help. All right, so that's the advantages and disadvantages to sole ownership. Secondly, we have what's called tenants in common, or TIC, tenants in common. When two or more persons holds an undivided, and we'll have to take a look at that word in a minute, undivided shares in a single property, they may do so as tenants in common. No owner can claim a specific portion of the property. So let me say that again. No owner can claim a specific portion of the property, as each has a right to possess the entire property. That's the definition of undivided rights. So no owner can claim a specific portion of the property. So you can own it 50-50, but you can't split it down the middle and say you own this 50% and I own this 50%, okay? There is no right of survivorship. That's another important thing to notice about tenants in common. There is no right of survivorship in the form of ownership, which means that each individual share passes to the heirs of the devisee as part of his or her estate. The share does not pass automatically to any other owners. So if you have tenants in common ownership with somebody and that person dies, the share does not pass automatically to any other owners. So there is no right of survivorship in the form of tenants in common. Okay? The third one is called joint tenancy. Joint tenancy. So in joint tenancy, it's distinguished by each owner has an undivided interest with the right of possession to the entire property. All joint tenants' ownership must be acquired simultaneously. Okay, so you have to take ownership at the same time as everybody else. New tenants cannot be added later without creating a new joint tenancy. There is only one title to the property, and each owner has a share in it. Only one title to the property, and each owner has a share in it. If a share is sold, the new owner must join with the remaining joint tenants to create a new joint tenancy. There's another requirement. The interest of each tenant is considered equal, regardless of how much each has contributed. If there are two joint tenants, each would own one half. If three, each would own a third. The major distinction between them, although these are very different above, but the major distinction is the right of survivorship. When a joint tenant dies, his or her interests pass automatically to immediately to the remaining joint tenants. So in tenants in common, if your partner dies, you get a new partner, and that person will be an heir. So it could be their wife or their kids or their husband. In joint tenancy, it goes back to the other owner. Okay, so those are very different ownership types, and you have to evaluate which one is right for you. The last one is tenancy entirety, and that is used for married people. Okay. So that wraps up the section on classification of property ownership, and I thank you for being with me. If you need more information, go to jdavidchapman.com, jdavidchapman.com. Thank you for being here.